9 justices, 9, not 5, not 6, not even 8, 9. And not a single one of them disagreed. For the first time in years, maybe decades, every single justice on the United States Supreme Court, from the most liberal to the most conservative, looked at each other, looked at this country, and said the same word out loud. No. No to the way police use of force has been judged in this country. No to a legal shield that departments have hidden behind for years. No to a rule that basically told courts, don't look at what the officer did before the shooting. Only look at the last second. And right now, I'm talking right now, police departments across America are sitting in emergency meetings, rewriting training manuals, calling their lawyers, and asking one question they never expected to ask. What do we do now? Stay with me, because this ruling affects every single one of you watching this, whether you've ever had a run-in with police or not, whether you're a cop yourself or you've never met one. And this changes the game. The story that started it all. Let's go back to April 28th, 2016. Houston, Texas. A man named Ashton Barnes is driving through the city. He's pulled over by Officer Roberto Felix Jr. And here's the reason for the stop that you need to hear carefully. Toll violations, not a robbery, not a shooting, not a car chase, a toll violation, the kind of thing that most people would get a ticket for and go home. But what happened next would eventually land in front of the 9 most powerful judges in America. According to the dashcam footage, when Officer Felix approached the vehicle, Barnes began to move the car. Felix jumped onto the door sill of the moving vehicle. Seconds later, he fired 2 shots. Ashton Barnes died. Now, you might be thinking, okay, that sounds like a split-second decision. And that's exactly what police departments across the country argued for years. It was a split-second decision. You can only judge what the officer was thinking in that moment. And that argument, that legal shield, has a name. It's called the moment of threat doctrine. And for years, in courts across the country, it worked like a magic trick. Plaintiff lawyers would try to show everything leading up to the shooting, the training, the tactics, whether the officer escalated the situation himself, whether there were other options, and the court would say, nope, we're only looking at the last second. Did the officer face a threat in that moment? Yes. Then the use of force was reasonable. Case closed. Ashton Barnes' mother, Janice Barnes, refused to accept that. She sued. And the case went all the way from Houston, Texas, to the marble steps of the United States Supreme Court. The old rule, what police departments had for decades. To understand why this ruling is massive, you have to understand what the old rule actually allowed. Going back even further, 1989, a case called Graham v. Connor. This is the foundation of every police use of force case in America for the last 35 years. The Supreme Court said, when judging whether a police officer used excessive force, courts must look at whether the force was objectively reasonable, using a totality of the circumstances. Sounds good, right? Totality of the circumstances, look at everything. But here's where it gets tricky. Over the years, several federal circuit courts, we're talking the 2nd Circuit, 4th Circuit, 5th Circuit, and 8th Circuit, developed what became known as the moment of threat rule. What does that mean in plain English? It means when a lawsuit comes in saying an officer used excessive force, those courts said you could only look at the exact split second the officer perceived a threat and pulled the trigger. You couldn't look at what happened 5 minutes before. You couldn't look at whether the officer put himself unnecessarily in danger. You couldn't ask, did the officer's own actions create the dangerous situation? Think about what that means in practice. Let's say an officer approaches a car, jumps on the side of a moving vehicle, and then shoots the driver because the car is moving and he claims he felt in danger. Under the old moment of threat rule, a court would look at that final second, officer on door, car moving, perceived threat, and say, reasonable force done. The family gets nothing. The officer faces no consequence. Under this rule, officers could theoretically create dangerous situations through their own poor tactics and then use that very danger they created as justification for deadly force. Legal experts have spent years arguing about this. Civil rights attorneys called it a blank check for deadly force. Police unions called it a necessary protection for officers making split-second decisions under stress. And for years, in 4 major circuit courts covering huge parts of this country, the police unions were winning. Until May 15th, 2025, the ruling drops what the court actually said. The Supreme Court agreed to hear Barnes v. Felix. Arguments were held in January 2025. And in May, Justice Elena Kagan, writing for a unanimous court, dropped the hammer. And I want you to hear the actual language the court used, because it's clear, it's direct, and it's devastating to the old rule. The court said, and I'm paraphrasing here to give you the spirit of it, that no rule that prevents courts from looking at events leading up to a police shooting can be reconciled with the totality of the circumstances approach. In other words, you cannot put on blinders. You cannot look away from what happened before the trigger was pulled. The whole story matters. Justice Kagan wrote that a court deciding a use of force case cannot review the totality of the circumstances if it is effectively put on chronological blinders. That's the analogy they used. Blinders. Like a horse that can only see straight ahead, courts were being forced to wear blinders, and the Supreme Court just ripped them off. Now, here's something that made even more people take notice. It wasn't just the liberal justices. Justice Kavanaugh, one of the more conservative members of the court, appointed by Trump, wrote a concurring opinion, joined by Justices Thomas, Alito, and Barrett. These are the conservatives, and while they agreed with the outcome, Kavanaugh wrote separately to emphasize the real dangers officers face during traffic stops. Let that sink in. Even the most conservative justices on this court said the old rule was wrong. That's not a partisan ruling. That's not a political statement. That is the entire legal establishment of the United States of America saying this needs to change. The ruling sent Barnes v. Felix back down to the lower court with clear instructions. Look at everything. Look at the whole encounter. Look at whether the officer's own actions contributed to the danger. Then decide if the force was reasonable. Why police departments are scrambling. Now let's get into why this is causing panic in police departments right now. Because here's the thing. This isn't just about one case. This isn't just about Ashton and Barnes in Houston in 2016. This ruling rewrites the rules for every use of force case going forward in every court in America. What does that mean practically? First, training is being rewritten. Every cop in America is trained with certain assumptions about what is and isn't legally defensible. For years, departments in those four circuits, 2nd, 4th, 5th, 8th, trained their officers knowing that if things went sideways, the moment of threat doctrine gave them cover. If the officer faced a threat in that final second, the rest of the encounter could be swept aside. The training has to change. Now, as one law enforcement expert put it, and this is a direct quote from a former law enforcement official, every single officer that's trained is going to know how the Supreme Court found on this case. It's going to affect how they interact with everyday people on the streets. Second, qualified immunity just got harder to use. Qualified immunity is the legal doctrine that protects government officials, including police officers, from being sued unless they violated a clearly established right. It's been a massive controversy for years. And while this ruling doesn't kill qualified immunity directly, it makes it far harder to get cases thrown out early. Before, in those four circuits, a police department's lawyers could go to court and say, Your Honor, look only at the final second. Threat was perceived, force was reasonable. Dismiss the case. That motion to dismiss, called a summary judgment, worked a lot of the time, and those cases never made it to a jury. Now, with the totality of circumstances back on the table, those same lawyers walk in and the judge says, I need to see everything. The whole encounter, every decision, every tactic, that's much harder to get dismissed. More cases go to trial. More cases cost cities millions. Third, de-escalation is no longer optional. It's a legal necessity. This is huge. Training, pursuit policies, and de-escalation protocols are now more legally relevant than ever. Courts are now being told to evaluate the entire chain of events. That means if an officer skipped de-escalation steps, if an officer created a dangerous situation through his own tactics, if an officer had options he didn't take, all of that is now fair game in a lawsuit. Departments that have been dragging their feet on de-escalation training are now scrambling. Because if an officer uses deadly force and the plaintiff's attorney can show that proper de-escalation would have avoided the situation entirely, that department and that officer are now much more exposed. Fourth, the financial stakes just got catastrophically higher. Cities and municipalities have insurance for police misconduct. They pay settlements. And when those settlements go up, when more cases make it past the summary judgment stage, it costs taxpayers money. Lots of money. We're not talking about small amounts. Police misconduct settlements in major American cities have cost taxpayers billions of dollars over the years. This ruling has the potential to significantly increase those costs because it opens the door for plaintiffs to bring in far more evidence than they could before. what this means for every day. Okay, so we've talked about what this means for departments, for training, for lawyers, but what does it mean for you, for the person watching this video right now? If you've ever had a traffic stop go wrong, if you've ever felt scared, confused, or mistreated during a police encounter, you need to hear this. More cases can now be heard. Before, in those 4 circuits, a lot of lawsuits filed by families of people killed by police were thrown out before they ever reached a jury. A judge would look only at the final moment, say the officer faced a threat, and dismiss the case. Family gets nothing. No trial, no accountability, no jury appears getting to decide. Now, more of those cases survive to trial. Families get their day in court. A jury, real American citizens, gets to look at the whole story and decide whether that use of force was justified. The burden of justification just got heavier. This doesn't mean officers can't use force. It doesn't mean every shooting will now result in a conviction or even a civil verdict against the officer. What it means is that the justification for that force now has to account for everything. Every decision, every tactic, every moment leading up to the trigger pull. If an officer acted professionally, followed training, attempted de-escalation, and still faced a genuine threat, they will still be protected. This ruling doesn't end reasonable use of force. It demands that the force actually be reasonable throughout the whole encounter. Civil rights organizations are calling this a step toward accountability. The NAACP Legal Defense Fund called this decision a significant advancement for police accountability. Legal scholars across the political spectrum, including libertarian organizations like the Cato Institute, praise the ruling. The Cato Institute wrote that this decision is about keeping cops accountable. Think about that. One of the most conservative libertarian think tanks in the country agreed with civil rights advocates on, but law enforcement has a different view. To be fair, and I want to be fair here, many in the policing community have raised legitimate concerns. Police unions argue that officers already make life and death decisions in milliseconds under extreme stress, with incomplete information. They worry that expanding the legal lens will second-guess officers with the luxury of hindsight, the kind of Monday morning quarterbacking that doesn't reflect the chaos of a real encounter. Kevin Lawrence of the Texas Municipal Police Association put it bluntly, accountability is not really a problem in law enforcement. He represents a view held by many officers who believe the system was working fine, and this ruling introduces unnecessary risk for cops doing a dangerous job. Both perspectives matter, and this ruling doesn't pretend the job is easy. It just says, when someone dies, we're going to look at the full picture. The bigger picture, what comes. Here's where I want you to really pay attention, because this ruling is not just about Barnes v. Felix. It's not just about what happened in Houston in 2016. This is the beginning of something much bigger. Lawsuits are going to be re-examined. Cases that were previously thrown out in those 4 circuits may be subject to new scrutiny. Families who were told, no, the court won't hear your case, may now have grounds to push again. Attorneys across the country are already poring over dismissed cases to see what might be re-litigated under this new standard. Police reform legislation is back on the table. For years, Congress has debated federal police reform legislation. Bills have passed the House and died in the Senate. And one of the biggest sticking points has always been qualified immunity. This ruling, while it doesn't touch qualified immunity directly, changes the calculus. Because even without eliminating qualified immunity, the expanded evidentiary standard means more cases go further, cost more, and put more pressure on departments to reform from the inside. Watch for new legislative pushes in Washington. Watch for state legislatures moving on police reform. This ruling gives reformers a new argument and new momentum. Police training is entering a new era. The legal landscape just shifted. Departments that are smart are already investing in de-escalation training, crisis intervention, implicit bias training, and tactical decision-making courses that emphasize avoiding force rather than just justifying it. Companies that make tools like the BolaWrap, a restraint device designed to reduce the need for deadly force, are already citing this ruling in their marketing to departments. Money talks. When departments realize that poor tactics before a shooting can now cost them in court, they will invest in the training that prevents those situations. And here's the quiet truth. Nobody's saying loudly enough. This might actually make policing safer for everyone, officers included. When departments train better, when officers have more tools and better tactics, when the culture shifts toward de-escalation, officers get hurt less too. Studies consistently show that when departments prioritize accountability and better training, both civilian and officer injury rates go down. The Supreme Court of the United States just told every police department in America the entire encounter matters, the whole story matters, You are accountable for every decision you made, not just the last one. That is not a radical idea. That is the most basic standard of accountability that exists in any other area of American law. Doctors are judged on their whole course of treatment. Financial advisors are judged on every recommendation. Teachers, architects, engineers, they're all accountable for every decision in a chain of events. For the first time, clearly, unanimously, the Supreme Court said, so are police officers. What happens next depends on how departments respond. It depends on how courts apply this new standard. It depends on whether Congress moves, whether states act, whether departments invest in real reform. But one thing is certain. The legal landscape has permanently changed. And if you care about accountability, about justice, about the idea that in America nobody is above the law, this is the ruling you've been waiting for. If this video opened your eyes to something you didn't know before, hit that like button. Share this with someone who needs to hear it. Subscribe, because we cover the stories that actually matter, the ones that affect your rights, your safety, and your country. I'll see you in the next one.